Good day to you and welcome to another Paddocks Club video tutorial. We are at the moment expecting that the draft regulations under the Sectional Title Schemes Management Act and those under the Community Scheme Ombuds Service Act will be published for public consultation in the near future. So I thought I would take this opportunity to just touch on two issues. Firstly, why do we need a CSOS at all? Well, there is a considerable distinction between community schemes and conventional property ownership, that being the type in which each property is entirely separate. And the process of managing and controlling a community scheme is very much more complicated. There's always the question of who must carry out repairs and maintenance to what parts of the building. There's the question of who is financially responsible for those particular repairs. But perhaps the most challenging complexity which is involved in all community schemes is dealing with an ever-changing group of individuals who obviously seek to advance their own interests within the community. Another issue is that almost all the non-subsidised housing built since the 1970s is in the form of one or other type of community scheme. So there are many, many more of these. A very substantial proportion of South Africa's urban houses is in complexes. And the complexities inherent in community scheme management warrants assistance by the government. This is a fundamental rationale for the existence of the CSOS. The CSOS is also seen as an essential prevention or mitigation of the disruption caused by disputes in community schemes. Disputes are inevitable, but when they do arise, either amongst owners or occupiers or between other stakeholders, there must be reasonable access to justice, and that is the purpose of the CSOS. So let's just quickly, as the second item for this tutorial, look at the CSOS's role. The first and most important one is dispute resolution. When a community scheme's governing body, an occupier, an owner has a dispute with another person who also has a substantial interest in the scheme in regard to the administration of that scheme, they'll be able to approach the CSOS for assistance in resolving that dispute. They may have to use internal dispute resolution mechanisms before they come to the CSOS, but one way or another, they will be able to move forward to probably go through conciliation in the first instance, but if that's inappropriate or unlikely to succeed, then there'll be adjudication, which hopefully will be fast-tracked. In the process of doing this, the CSOS will have to train adjudicators and conciliators. It's one of their stated functions in the Act, and the people who carry out these functions, either on a full or part-time basis, will need a working knowledge, obviously, of the law and practices involved. The governance documentation for sectional title schemes will be taken over from the deeds registries by the CSOS, and so custody and examination of the governance documentation only for sectional title schemes, including, however, those retirement developments and others that are sectional title schemes, will be handled by the CSOS. The CSOS will be monitoring all community schemes, which will all have to pay levies and render annual returns, including copies of their annual financial statements. Finally, there is the raising of awareness and education in the general public of South Africa. The Act recognises that it's important to educate those who have rights and obligations in community schemes and to raise awareness amongst them so as to prevent disputes, a significant number of which are caused by a lack of information or understanding of community schemes. As I say, I'm hoping that the draft CSOS and STSM regulations will be published for public comment soon, and I thought that this would be just a sensible sort of preparation for that process in which I hope that you are going to play an active part. Thank you for joining me, and if you have any questions, let's deal with them in the discussion forum.